So we'll get started. Good afternoon, ladies and gentlemen, and welcome to our first client seminar of 2025. Feels a bit weird saying that. For those of you who don't know me, my name is Susanna. I'm your MC for today. And like I said a couple of years ago, half the time I don't know what will come out of my mouth, neither do you. So let's see how we go. Today we've got quite a bit lined up for you. Our team will be, if my clicker works, our team will be discussing some Section 18 issues. They've always been a hot topic, but I think they'll be a bit more intriguing to you all today in light of the recent amendments to the legislative provisions that have come into effect as of the 1st of December 2024. You'll also receive an update on some cases that Chrissy and Tracy have prepared. I don't know that there's really a theme to them because you'll be hearing a little bit about costs, a little bit about noise-induced hearing loss and the like. So look, nonetheless, you'll have some really key takeaways that are going to be important to you and your businesses. So stay tuned. Speaking of our team, on the last occasion, our team got a little bit smaller, particularly given that Mark Kim ended up retiring. But since then, we've had some other members come on board, and we've welcomed back Oliver Fragnito to the KJK legal family. And as of this week, we've also gained a new member, Lauren Naxteen, at the front here. If you haven't heard from Lauren yet, I'm sure you will in due course. Now, whilst we like to leave the best till last, we thought we would...
Sorry, we have left the best.
Oh, look, mate. Just talking about herself, of course. No, we want to switch it up a little bit. So rather than leaving a guest speaker to present at the end of the seminar, we thought we'll start off with our guest speaker. There's so much I could say about this particular presenter, but I'll try and sort of do it in a bit of a nutshell. Most of you know him, or at least you have heard of him. He's been cited in many cases by the South Australian Employment Tribunal. He is a wealth of knowledge when it comes to noise-induced hearing loss matters, and he's well known for conducting noise surveys here in SA. However, he does a lot more, so you might be surprised to know, for example, that he also does light testing. He monitors dust levels and performs ergonomic assessments as well, amongst many other things, which I'll let him expand on later today. I'm told that he had a fairly that he worked in a bit of a self-directed manner with his last employer, and then thought, why not just start my own business? And he did so in mid-2000, if I'm not mistaken.
Sure. The day that GST started.
Yeah, there you go. So I'm told that it's been a very rewarding journey. It's been intellectually stimulating, but also challenging, particularly from an admin, point of view. Doing all those reports.
I do everything. I'm accounts, although my wife sometimes pays the bills, so that's good.
What's really special about this guest speaker today is that he strives to provide a quality and timely service. So as you listen to his presentation today and get to know, the type of work that he does do, I want you to consider perhaps engaging his services if you haven't done so previously. Today he will be discussing fictions and facts pertaining to noise-induced hearing loss, but we'll also have a little bit of a show and tell, and it looks like I'm going to be a bit of a guinea pig, so it hasn't been rehearsed. Could go well, it might be an epic fail. We'll have to wait and see. I have been speaking to you quite a lot actually lately, and I must admit, without fail, every time I speak to him, I either learn something new from him or I learn something new about him. And as of yesterday, I found out that he really enjoys trail running, and in September this year, him and his wife are heading overseas to do a 14-day walk from France to Switzerland, right? So that's pretty bloody impressive. Look, on that note, ladies and gentlemen, please give a massive round of applause for Mr. Paul Dewing.
Thank you. Thank you for that warm welcome. Noise-induced hearing loss claims are not a new phenomenon, as we know. But the numbers are just ridiculous and out of control. And I've been doing investigations for hearing loss claims since 1991, and I guess I have never seen such a wave sustained as what we've been seeing, probably for about the last maybe 4 years. I mean, I remember in 2020, during COVID, I was sitting around doing next to nothing for about, I reckon, 4 days a week. And I thought, what am I going to do? But then, like, this wave of claims came in and employers started opening up because they wouldn't let me through the doors until it was, safe to do so. And I guess you've probably all had the experience of having multiple claims, and probably with that is huge frustration and annoyance and probably anger. I mean, I've never been so angry in my life about some of them, and I'm not the employer. I'm not even the claims person making the determination, but they just annoy the hell out of me sometimes. When I get a claim yesterday to look at, to do a report on, for someone who worked in 2009 for 20 days. I've seen even less go through the system, and you go, what do you make of it? And the whole, I guess, legislation and issues around all that just feed into the problems. So what I want to cover is a number of different things, but firstly, my title is Fictions and Facts Pertaining to Noise and Noise-Induced Hearing Loss. My background is as an occupational therapist, and then I went off and did work health safety at uni, postgraduate, and then ergonomics, and then finally occupational hygiene. So most of my services are really doing investigations of hearing loss claims. I started doing them and literally fell into doing them in 1991. I estimate, and I don't think I'm overstating it, probably about 6,000 claims to date. I wish I'd kept a log and numbered from 1 upwards, but I never started. Obviously I do noise surveys, lighting surveys, different types of dust, welding fume, gases, all sorts of stuff. Still do ergonomic assessments. Don't really do any return to work services as an OT, partly because I don't want to. Sick of seeing claimants in the whole return to work process as well. I've done it for too long, too jaded. Sometimes do common law reports to do with work health safety injuries and also ergonomic factors, and sometimes occupational hygiene. So that's my background. I got onto this thought about talking about fictions or facts because of something I read about what Tracy put together actually last year or the year before. And I thought, that's a really good topic, because to me, there's so many fictions around noise-induced hearing loss. And Judge Gilchrist described the first two, and I've sort of continued on a bit, that the whole of the hearing loss is deemed to have occurred prior to submitting a claim, and all of the losses occurred with the last employer unless there's proof to the contrary. Now we know that they are fictions, that they're legal constructs, and they have no scientific basis behind them. And that's a huge problem when it comes to making sense of noise and noise-induced hearing loss. I've got some facts as well, spread out through the whole session. The ear is complicated. We've obviously got the external part of the ear. We've got the middle ear, which is the eardrum and the 3 bones, and the inner ear, which is the semicircular canals, and the cochlea. The cochlea contains the hair cells. The hair cells are the primary source of damage from noise. And the hair cell damage happens due to biochemical or oxidative stress, and possibly also interacting with mechanical or shearing forces because of the hair cells moving. So it's a combination of factors. Almost all hearing loss from work or industrial noise happens in the cochlea, except if there's explosions. So if someone's exposed to explosive noise, there might be other examples, they will get mechanical disruption to the bones in the middle ear. And I've come across that a few times over the years. One notable case was this chap walking back from smoko break to his workplace, into the workplace on a building site. One of his work colleagues had filled up a plastic fruit and veggie bag, just the little clear ones, with acetylene gas, and lit it near his ear. And it went bang, obviously, and he got asymmetrical hearing loss, so one ear worse than the other, and really bad tinnitus. And, that's an example of not just noise-induced, but he would have probably ended up with mechanical damage to the middle ear. Now, some of the facts around sound, decibels and standards. Sound has features of both intensity and also frequency. Now, we perceive intensity as loudness and we perceive frequency as pitch. So the normal human ear that's unaffected by noise, and Tracy was saying that, you got a bit of a hearing loss. So you may not have the full range. I can't hear above about 15,000, I think, myself. Normal hearing is between 20 and 20,000 hertz. So less than 20 is infrasound, greater than 20,000 is ultrasound. And the normal range of hearing is between about 0 decibels and the threshold of pain of 140, which is meant to correspond to a jet engine on takeoff. Now, I've never measured, strapped down to the runway at Adelaide Airport with a jet taking off, but that's what's being reported. 0 decibels is not zero noise because we only hear across that frequency range. We don't hear everything. We don't hear what dogs and cats can hear and other animals. I think cats can hear up to about 50,000 plus or something like that. It's quite amazing. The range of sound energy we hear is a difference of about 10 million. And the pressure scale, which is in pascals, is compressed using logarithms, and we end up with a decibel scale. And that's important to understand because when you look at the decibel scale, every jump in 10 decibels is 10 to the power of 1 difference. So if you go from 80 to 90, it's 10 times. If you go from 80 to 100, it's 10 squared or 100 times. So it means that you've got less exposure time at higher levels in terms of it being safe. The key standard is around working out the equivalent continuous noise level, which sounds like a mouthful, and it is, or the average noise exposure equivalent or equated to an 8-hour period. And the work health safety regs require that the average noise to be less than 85 dBA, so it's on the A scale, and for the peak noise to not exceed 140, which is on the C scale. Now, the peak noise level is important for situations like impact and impulsive noise from guns. And Susanna and I were having a conversation about guns the other week. Starting pistols, that's come up with PE teachers in Department for Education. Nail guns on building sites, explosive tools, punch presses, hammers, that type of thing. When it comes to impulsive or impact noise, we're less concerned about the average noise, much more concerned about the peak noise. Fiction or fact, that noise capable of causing noise-induced hearing loss can only be when the average noise adjusted to an 8-hour period is close to, equal to, or greater than 85 dBA. Well, you've got my notes, so you know what my thoughts are around this. I think it's a fiction, maybe a bit of a fact. It's a reasonable figure, but it's not black and white safe. And that's really important to know. It depends on the duration of exposure over time. And this is really important to take in. It complicates the whole determination process, but it's scientific fact that the risk is greater at lower levels of average noise when the duration in years becomes greater. In other words, there's a greater risk at, for example, 80 dBA over 40 years of exposure than over 5 years of exposure. Now, most of us go, yeah, someone's exposed to 80 in their workplace. Who cares? That's not going to cause hearing loss in the last 2 years. And it probably didn't, but over 40 years, it probably has. So, as I've got in there, this collides with the premises always using 85 as the benchmark. And this is something I can't reconcile in my head because, this claim for 20 days, of course they wouldn't have been exposed to noise sufficient from a medical point of view, but what is the legal interpretation around that? And our eminent lawyers can answer that better than I can. But we know what the answer is. You're kind of doomed, basically, sadly. And the other thing is individual susceptibility, which there is no way of quantifying because we all have different genetics and most of us will sit in the You know, remember your statistics, the normal distribution curve that's sort of shaped like a bell-shaped curve. Most of us kind of sit in the middle of it, but there's always the outliers at the top and bottom. I mean, I've seen Boilermakers over the years, for example, who've never worn hearing protection and got next to no hearing loss, and then their work colleague has got massive amount of hearing loss. The difference is genetics. One's just lucky. That's the truth of it. Fiction or fact? Noise capable of causing noise-induced hearing loss can include intermittent noise greater than 85 dBA, even though the average noise over an 8-hour period is substantially less than 85 dBA. Now that's probably a mouthful to think about. What I'm getting at here is if someone's exposed to intermittent noise, let's say from hammering now and again, but the overall average over the 8-hour day is much less than 85, is that a risk when it comes to noise-induced hearing loss? Well, I think if you believe that intermittent noise is the key thing, there's no foundation in science. Now, I've had a look at this extensively in the literature. I can't find anything that backs it up. Why have I looked at it? Because as far as I can see, these decisions are happening in the tribunal. All national and international guidelines are based around the average and the peak noise exposure. So, as I've got on the bottom, might be provocative. Therefore, if decisions are being reached that dispute only on the premise of intermittent exposure to 85 dBA, this is a legal fabrication that defies science. I can't find anything that backs it up. And I've looked, you know, Google Scholar, looked at journals, whatever I can find about that topic.
So I've got a question for you, or I guess a couple of our members of the audience. Turning back to that, an example, for example, dentist?
Yes.
Anyone else?
Oh, dentists are a good one. Actually, for some reason, I never saw any dental claims until about 3 or 4 years ago. Never. And you remember I've been doing these for about 34 years now. But they're just coming out of the woodwork. And what do I think about dental practitioners, which could be dentists, dental therapists, dental hygienists, dental nurses, dental assistants, you know, there's a whole gamut of people. Their exposure, based on the testing I've done, I only did another one a few weeks ago in a dental clinic, is mostly less than 80, much, much less than 80. The problem is we don't really know what their exposure was back, say, 10, 20, 30 years ago, because it seemed like the instruments might have been different. Like they used to have stainless steel bearings in the high-speed turbines. Now they've got ceramic bearings in them. And look, I never measured back then. And there's really limited data or information on the internet and really good, robust research articles on it to really help us out. I mean, some of the stuff that's been done in terms of research is really, really poor. You know, they're using noise meters that are so basic. You know, this is my new one. Better not drop it. I only got it last month. It cost me $8,000. And they're using instruments that are like less than $500. And it's like, because I know what they are. It's like, and they're putting them in as journal articles. But
say, for example, even back then, there was intermittent exposure to, let's say, above 85 dB.
Sure.
You're saying that, you know, potentially someone from Romania is calling me, what on earth?
Well.
Anyway, so you're saying, well, you know, they wouldn't have the suctions on all the time and whatnot, and therefore...
Therefore, the risk is not substantial. Now, there seems to be evidence with dentists and dental practitioners that suggests that some are probably at risk. But if you looked at the percentage hearing loss that they might get, the binaural loss and then the WPI, is probably relatively low. So it's very hard to say that no one's going to get hearing loss because there does seem to be some indication. There also seems to be an indication that with dentists, that their right ear is slightly more exposed and they should get slightly more hearing loss in the right ear, whereas those who assist them are probably going to get hearing loss more in the left ear. And if you look at their positioning in the room around the chair and the patient's head, that kind of supports all that as well. So, you know, you look at the audiogram and go, does it make sense or not? But like all things noise and noise-induced hearing loss, nothing is clear cut as far as I'm concerned. And the more I know, the more I don't know. And that's a problem, isn't it? When you sort of, you know, you get to understand the topic, but it's complicated. Any other questions? Noise capable of causing noise-induced hearing loss only relates to the average over an 8-hour period, or can there be exceptions? And if so, what could they be? Without reading my notes, which you probably already have, can you think of any exceptions where the average is not the key thing?
Well, the higher it is, the noise exposure is really high, it can be a much shorter period.
That's right. So if you're looking at like impact or impulsive noise, so gunfire, you describe an artillery noise as impulsive, very short but intense burst of noise. Hammering would be more impact noise. Another example could be tonal noise. And to be honest, I looked at this extensively to do with another claim a few months ago, and I can't find evidence to back it up. But my suspicion is that if you're exposed to a very high-pitched noise, sort of very discrete octave band that's intense, like smoke alarm, for example, then you may be more at risk. Now, this claim, which was interesting, this claim was for someone testing smoke alarms, and they didn't wear hearing protection from what was reported. And they used to test, like, basically with a clipboard or their notepad or whatever it was, and push up like that and try to protect one ear, so one ear was less exposed than the other ear. So I tested this. Actually, I think I took a photo. It looks ridiculous, and you'll see it a bit later. I tested it to see what the difference was. Anyhow, the claim got rejected. And weirdly, the worker rang me up, the claimant rang me up when I was driving along the highway, coming back from the York Peninsula only about a month ago. And it was like, oh, great, I've got to talk to this person. She was really nice, and she was self-represented, so she didn't have legal representation, but I don't think she pursued the dispute. I actually think that it was a reasonable claim. In my head, I actually thought it was reasonable. Anyhow, Dr. Diamandis didn't, and it got rejected. So who's Paul Dewing? What do I know? Nothing. So there you go, that's fine. And also longer shifts. You know, think about longer shifts and the impact, because if someone works more than 8 hours or more than 5 shifts a week, then you need to grab that noise and squash it back to an 8-hour period over a 5-day / 40-hour working week. Now, you get some really weird scenarios, like I did a job at BOC Gases in Whyalla the other week. They're on the site of Liberty Steel, which is, we know, is in receivership. But the blokes at BOC work 12 hours a shift, and they kind of do this weird rotation, 2 days, 2 nights, 2 off, whatever, you know, and it kind of goes on like this. And you go, how do you make sense of that? So all you can do is mathematically jump on the calculator and work out, squash the 12-hour period back down to 8 hours, and that's, I think, the best you can do, because it's just too hard to figure out what happens over time. Broadband compared to tonal noise, just to explain what that's about. A lot of noise sources, you get multiple frequencies of noise, but in the case of the one on the top right, that is actually the example of a smoke alarm in the house. So you've got really discrete, like high intense noise at 3.15 kilohertz, so 3,150 hertz. The one on the bottom is either an extraction system in a kitchen or just the cold storage like the fans running. I mean, people claim all the time they work in kitchens and they're exposed to really loud extraction hoods. And you go, well, are they really? I mean, that's not my experience testing tons and tons of them. I've done 5 kitchens this year so far. I'm waiting for more to come. Like Jeff keeps sending me kitchens every now and again for aged care. Here's another fictional fact. Intermittent and continuous noise are the same from a risk consideration if mathematically the average is the same figure. So just imagine someone exposed to steady noise at 85. Is that difference in terms of risk than someone exposed to intermittent noise that still adds up to 85? And the answer is, I think it's fact and fiction. From a mathematical point of view, it's the same. So the acoustic energy is the same, and it's what we refer back to the equal energy hypothesis. I actually talked about this at the tribunal once, and now it's been written into a case, and they misinterpreted what I was talking about. You know, when you get put on the spot with no knowledge about what question you're going to be asked, you know, I wish I'd answered it slightly differently, but anyhow, I didn't. But the thing is, if you're exposed to intermittent noise, you probably do get some recovery of the hair cells. So the whole concept is probably overstating the risk a bit. I mean, as an example of, you've probably all seen people using what we call quick cut saws to cut concrete. So they're concrete cutting machines, they're holding them, they're as noisy as, you know, you'd never know. Like, they also spit out respirable crystalline silica out the back unless they've got water on them. And they generate about 105 decibels. Now, if you're exposed to 105, because I worked this out yesterday, just to double check, 105 for 6 minutes, and you sit out in the sunshine for the rest of the day, as in 7 hours, 54 minutes, that equals 86 decibels on average. So 6 minutes of high intense noise exposure can make a big difference. Employers don't understand that. When you try to explain, look, intermittent high noise can still be an issue. What are we doing when we're measuring noise? We're measuring on the A scale. The A-weighted frequency scale is weighted to reflect what we hear as humans. And you can set the meter to a sampling rate of either slow or fast. I tend to have it on the fast setting most of the time. The key is still trying to get the average noise as much as you can, and separately we can measure the instantaneous peak noise. Here's an interesting one. In noise testing reports, the maximum and the peak reading is the same meaning. The answer to that is no, they don't. Whilst they seem like the same word, they are not the same when it comes to acoustics. The maximum has a time weighting, either slow or fast. The peak reading has no time weighting. Now, I won't bore you with the physics and the reason why all that came about, and it's a bit hard to understand what went back, way back in time in the 60s, or even prior to that. What does a noise survey actually involve? The aim is to work out the range of noise, the average noise, and clarify the peak noise. And before testing, I always try to get as much information as possible. Sometimes I'll go out to a site beforehand and basically scope it out if I don't really know. I've got to do a job at a warehouse, a distribution centre, probably next week. And I'm going to go out there because when I spoke to the manager today, he said, look, why don't you just come out and that'll give me a better idea, because we need to put noise loggers or noise dosimeters on the employees, and we need to figure out, you know, how many, and I've only got so many myself anyhow. Normally I try to measure for long enough to get a clear idea, partly because I really want to get good robust data, and also want it to be defendable as much as possible, because you cannot believe how annoyed I am, increasingly over the years, how the legal reps just want to dig holes in everything that I generate. And look, because nothing is perfect. There is no perfect noise survey. I did one yesterday at the QEH in the kitchen, and that actually worked out really well. But they're not always like that. You know, sometimes you go to sites and you go, oh, things break down, and you go, oh, great. I mean, there's just a whole heap of things that happen that make it hard. Always use my handheld meter. So my really good one's this one. And I use noise dosimeters or noise loggers, which are these little things. So these don't look like much for $2,500, but they're the ones I've got, and I've got 15 of these, although one's not working properly, so I guess it's only 14 at the moment. And I try to use both where possible. Sometimes I won't use the noise dosimeters. Like a job I've got to do in the warehouse, they want the office area tested, and there's no way I'm going to put one on someone in the office, because what it's going to do is pick up more of the employee's voice than the background noise in the office, which is really what we want to know. So we won't be doing that. So it really kind of depends as to what works best. So I've got my lovely big noise meter. That's like $15,000, and I've got a new one actually. It only came weeks ago. It's kind of my backup, and that cost me $8,000. So it's kind of like lots of toys, and I've got a graveyard of things sitting in the office as well, so that I don't really use. And 15 of these cordless ones. Also got 2 of these. These look ugly, and they kind of are with cords still to them, but they got their use because they've got dual mics, and that's really useful. And I've used it, for example, in a bus to try to get left and right exposure, especially now that the buses have got security screens in them, and it's really hard. You can't sort of stick your noise meter around to see what it is at left and right ear position any longer. So fortunately, the last one I did a few years ago, I took this with me and I had it, and I was able to feed the cables through the gap and pin it in place. And simultaneously, I think I actually put dosimeters on left and right shoulders of the driver as well, because the number of bus driver claims, you cannot believe it. They're just like mammoth numbers. You know, metro buses, school bus drivers, it just goes on and on and on. Anyway, I've done about 53 buses, I think, to date, so I think that's pretty reasonable. Oh, I put these photos up because they look ridiculous, and they are. So that one on the left was me doing the smoke alarm, because I thought, how am I going to measure left and right ear position, when I was trying to sort of tuck my ear like this, head to one shoulder. So I thought, I know what I'm going to do. I'm going to clip the mics to my glasses and do it that way. I know it looks ridiculous. And top right is where I use this. So I did a job at Northeast Isuzu, and they put in a brand new abrasive blasting chamber late last year. And they wanted me to measure the noise from the abrasive blasting, which is a ridiculous amount of noise, I can assure you. It's about, if you measure outside the helmet, because they wear a helmet, it's about 115 to 120 or more decibels, dBA. Inside the helmet, you still get anywhere from 95 to 105, depending on the helmet. So it's just really hard to rig this up with someone else. So I did it myself, and I wanted to wear hearing protection because there was no way I'm going to expose myself to that sort of noise willingly or unnecessarily. So I spun the little probe, which normally goes into the ear canal, and had it sort of facing, and taped it in place with as much surgical tape as possible. So, because trying to get the helmet over the top is really, really difficult because everything kind of dislodges. As I said, there's no perfect way of doing noise testing, and some jobs are impossible to test with a complete reliability, and there needs to be insight into that. It's critical to understand what changes have occurred in workplaces with equipment, plant, machinery, tools, whatever. And it comes down to interpreting the data as fairly and as accurately as possible. I strive to do that. I strive to be objective and step away from the whole thing and try to be as least emotive as I can when it comes to making sensible conclusions about cases. Go back to historic data. I've got decades of stuff sitting in my filing cabinet. The last 24 years is sitting on my computer, and I sometimes trawl through the data to see what the historic data showed as well. Key to do noise surveys is stay there on site. I can put these noise dosimeters on employees and basically walk away because I kind of, believe it or not, I kind of know what the noise is going to be for most jobs, except ones I haven't really seen. But I deliberately stay on site and use my handheld meter and take measurements, like short duration average measurements with that, plot the noise as much as, repeat tasks, repeat tools, repeat equipment, and just try to make sure it's validated, the whole thing.
Quick question. Do you find find that when you go out to certain sites, do you find that people try to make as much noise as possible, or do they sort of think, oh, Big Brother's watching, let me be a little bit more quiet than usual?
Yes. Well, one thing I always do is tell them these are not tape recorders. They're not recording your voice. They're noise loggers, so they're recording the decibels. I mean, I kind of repeat that so many times because it's true, but it also puts them at ease a bit because it's sitting, I pin these up here. I don't actually use the standard clip system very often. Sometimes I wear them myself actually. I want to see what my exposure is. So the clips don't really sit very nicely and they can pop if someone, I guess shrugs their shoulders. And so I deliberately use almost always the nappy pin system. Have you got these for your... No, you just use disposables. No. These... Now, these are great, I assure you, because sure I damage someone's clothing, but I don't really care. But they won't come off. So like in the kitchen yesterday, they're not going to come off. And, it'll fall into the food or fall into a vat or the steam kettle or whatever it was. So, and if someone's doing really heavy, rough work like welding, they're secure on their shoulder. Trying to get the pins even through like leather vests that welders sometimes wear is just hard work. Just imagine trying to clip them off with the standard clips. They wouldn't work. They just fall straight off. So I use those all the time. Now, as far as people playing games, yes, it does happen sometimes, and it's like only last month in January, that is, I was at a work site. I had 2 employees fitted up with the noise dosimeters, and the data looked really weird. Like the overall average was over 85 or something, or maybe 84, and I thought, that's not what my guess was going to be. And when I downloaded the data, there was this spike, 9:30 a.m. or something. Anyhow, I thought, I'm going to exclude that data. The software is really good. You can chop bits out and it recalculates the remainder. So I chopped it out. I sent the information through to the employer, and he then rang me up a few days later and said he'd had a chat with these blokes, and one of them admitted that he went into the adjoining factory and someone else yelled into the microphone. He said this person was a tool maker, you'd never expect him to do it, he said. But he yelled into it. So I was pleased to hear that. At least I knew I wasn't guessing wrongly. So noise surveys can reliably replicate the work conditions. It really depends on the method used. And some tasks are definitely hard to measure, like surgery. I did robotically assisted total knee replacement at Flinders Private Hospital last year. Really difficult to do it. Why? Because sterile zones, can't stand in there close, they wouldn't let me. It's like I couldn't put noise dosimeters on the surgeon or the nurses really. So that just makes it hard. So I had to kind of stand at a distance as close as they'd let me and then mathematically calculate it based on a formula. Dental's hard, abrasive blasting. Swimming instructors had a few of those over the years. How do we do those when, if they jump in the water and assist the kids? I can't put meters on them, so it makes it hard. Explosive atmospheres are an issue, and that's come up recently. I did a job for Elgas actually with LPG filling, so I had to use some of these, but I've got 5 of them that are intrinsically safe, so they're for explosive atmospheres. So they were able to wear those. And my handheld meter is not intrinsically safe, so I had to use this really old one, which has got a display on it, like a screen display. And that was as best as I could do it. This is actually really a dosimeter as well. But there is no intrinsically safe noise meters in the world. So another fictional fact, dosimetry is accurate and reliable. Well, fact and fiction. It's a tool, and it should, where possible, be used in combination with the handheld measurements. You can get overstating of the values, from people talking, so that does influence the actual data collection because you can't discriminate between that and the background noise. And also you get reflection of sound off the body into the microphone, and that can add 1 or 2 dBA. And really, all data's got to be interpreted as correctly as possible. Another one. The wearing of hearing protection is reliable to protect against noise-induced hearing loss. Well, it really depends on the attenuation or how much reduction you get from the hearing protection. So, you know, whether it's earmuffs, these earbands or earplugs, or I got some nice moulded ones made. These actually came only the other week. They got made in France, of all places, as it turned out. So they took moulds here in Australia and then sent them off to Normandy, to the factory in France, and they came back. They're great because they sit and seal really nicely. It depends on the fitment and the seal against the noise, and it depends on whether or not the employees wear hearing protection at all relevant times of exposure to noise. They're the issues. People don't wear earplugs properly, I can assure you, and they don't always wear them as often as they should, because they might go, oh yeah, I'll wear it when it's noisy, but they're missing the other relatively noisy times.
Or they take them out because they want to talk to their colleague.
Yeah, that's
I
right.
get that all the time. Oh yeah, you know, the employees, hearing protection is mandated, everyone's got their earplugs or whatever it is. And then but you know, when the supervisor comes along to talk to them, you've got to take them out.
That's right.
So, you know.
That's right. And if you work out the maths as to how much loss of reduction you get over an 8-hour shift, it's not good. The issue with earplugs is that people don't always insert them properly, or they reinsert them incorrectly if they inserted them properly in the first place. They don't always even put them in. I've seen them in back to front, sometimes sideways in the ear canal. People have got different diameter ear canals, like my wife's got really, really tiny, narrow diameter ear canals. They hurt, so she's not going to get them in at all. So really when we go to, I guess, events that are noisy, and I get her to wear hearing protection, it's like, got to wear earmuffs. Although, actually we went to Coldplay concert in Melbourne last year, and she just could not get the earplugs in her ear. I wanted to take one of my noise meters, but she wouldn't let me. She genuinely yelled at me and said, Paul, why do you have to always think about noise all the time? Can't you just do something without worrying about your noise meters? Right? And it was actually, I couldn't stop laughing because it was actually quite funny. But I didn't take them because I was more worried about security taking my meter, you know, because I was going to take this one with the twin mics, and like, this is like, you know. Well, that's right. As it turned out, security just sort of waved me through and I could have done it. But anyway, I was a bit worried. More worried about them than her response. But I told her I was going to tell that story. All sorts of earmuffs. Actually, before we talk about this last one, let's do a couple of little demos. Susanna, you can hold the noise meter.
What do I do?
Just kind of read the numbers, or just, put your hand through there.
So I don't drop it.
I know.
Because I'm not going to be
Always
able to
worried.
afford it.
I've never actually dropped it. What do you reckon would be the noise levels from the vacuum cleaner? Any guesses? 60? Does it sound loud or not? So it's sort of reading depending on where you position it. And remember, most of the time you'd want to do it at ear position, not at motor position. So it's well less than 80.
So I'm actually pointing this wrong.
Yeah, that's all right. So sort of, up here, up around sort of that height. Yep. So it's about 70 to 71. And you know, how many cleaners put claims in for hearing loss? Lots. And how many of them related to pull-along vacuum cleaners, upright vacuum cleaners, cordless vacuum cleaners, backpack vacuum cleaners, polishing machines, scrubbers. Actually, I did a job in the supermarket last Wednesday morning. from 4:30 a.m. because I had to meet the cleaner, except they turned up at 6 because they came in late. It's like, great, I've just got up at like 3 o'clock in the morning, get down there, and the levels were not high. The scrubber wasn't noisy. This is like a walk behind Tennant brand scrubber. The worker who's put the claim in said that the buffing machine, which looks similar, was noisier, and that it was opposite. You know, they actually gave their perception was not correct. You know, and we're going to talk about that with the affidavits shortly. Perception is not always reality, I can assure you. People say, oh, the extraction fans in the kitchen are really loud, I can't communicate. And you go, maybe, but I doubt it because I've measured, you know, tons of them, 100 probably.
So my family, we do have a cleaning business, and they're also a very loud family. So all of these, you know, vacuum cleaners and polishing machines that we utilise, it's not loud when we talk to each other.
It's loud. All right.
All right.
What's that one? So it depends on where you measure it, but that's sort of sitting at about 85. So, you know, most tradies, they're going to use some stop-start. If they're using, this is a basic one, but if they're using the impact tool, where the clutch bites, you get really high noise. And, you know, so if you're drilling or through timber, let's say into steel behind, and the screw bites, you get a really high spike, sometimes over 100. So that is an issue if they're doing lots of that. Hammering. I always love hammering. All right. I won't build it too hard. Let's see what we get. So that's about 90 almost. Yeah. So that was close to 90 without hitting very hard at all. So just imagine what happens when someone's really laying into steel or sheet metal. I mean, sometimes people think, oh, hitting steel is worse than sheet metal. You know, sheet metal like in air conditioning, ductwork, that type of thing. Sheet metal vibrates, and if it's not dampened, because it's not thick, sometimes it's just as bad or worse. And then it, you know, it depends on the tools. You know, the number of times I get contacted by a case manager from EML or Gallagher Bassett and ask the question, oh, Paul, is an angle grinder noisy? That's probably a bad example. Let's just say, is an angle grinder noisy? You go, well, what are they doing with it? You know, what disc have they got in it? How often are they using it? So, you know, some years ago I did some testing at a factory or workshop, and we tested a flap disc, which is more like a softer kind of domed disc on the angle grinder, compared to a grinding disc, where I guess you're grinding the top steel, or a cutting disc where you're slicing through, to see what the differences were. So, I mean, of course there's differences. So when someone asks me, oh, how much does a tool make? It's like, that's not the right question. It's what are they doing with it that really matters. Because an angle grinder, when it's at full revs, when you switch it on, is about 90. Now that's not good, but that's nothing compared to actually grinding or cutting, which is like 100 plus sometimes. So, yeah. And one more. Sorry. This is only a little Dremel tool. So, that's only about 72, 73, and we're not doing anything with it. But if you're grinding with it, or, you know, sanding something onto steel, then of course it's going to be worse. Okay. Sorry. A claimant's opinion is accurate and reliable, and affidavit statements are reliable. Well, I'm going to say it's a fiction. It's not always fiction, but when someone's exposed to tonal noise, and especially low frequency noise, which I measured, I gave the example with, say, vacuum cleaners, extraction fans, that type of thing, we perceive it to be loud, and it's not necessarily. And, you know, I was at Yatala Labour Prison in the kitchen the other week, another one doing noise, and I was waiting for the employees, otherwise known as the prisoners, to come, and I thought it was loud in there. That was my perception. I thought, this is really noisy. just because of the extraction systems running on over multiple sort of areas. But it wasn't, it was well below 75 in all cases, I think. The influence of pre-existing hearing loss, so when you read affidavits and someone says, I'm exposed to really high noise, and you go, but this is coming from someone with noise-induced hearing loss. How can they even actually interpret the noise properly when they can't hear it properly? Everything's distorted. And it's true, it is. When you talk to someone in the presence of background noise, we need to talk at roughly 15 decibels over and above the background. And it's what we call the signal to noise ratio. So if you're exposed to, let's say, 75 constantly, you probably need to talk anywhere from 85 to 90 to be able to talk clearly with someone or interpret what they're saying. And this allegation that is in reports quite often, by one legal provider in particular, that our client cannot understand 1 metre from someone means that the noise is greater than 90 dBA is complete rubbish. If you sort of look at how much noise you need to talk over and above background noise. So 80 decibels is not high background noise, but you need to talk well over and above it because of the signal to noise ratio. And it's going to be dependent on frequencies and tones and stuff as well. But it's inaccurate, and I've seen this in so many reports, try to debunk it, and it actually, what they're referring to is a book called Noise and Audiology, printed in 1978, because I bought this off Amazon Books a few years ago. I wanted to see what it said. I thought, what are they quoting from? So I found the chapter and actually have used that a few times, but they don't seem to be doing it quite as much, I've noticed.
And just to add to that, the other thing that I find interesting is, once again, going back to dentists and dental therapists and the like. Sometimes they say, well, the noise is so bad that we can't hear each other talk. But a lot of the time they've got their masks on and the noise is muffled, so you can't hear them talk because you don't know what they're saying under those masks, right?
Yes, that's right. So you've got that, and you've got the need to talk over and above whatever the noise is. So what I'm saying is perception is not always reality when it comes to noise. Sometimes, how often we read statements or affidavits and you've got consistent phrasing and sentences from one to the next. You go, oh, that's great, they're just copied and pasted. Sometimes they're missing critical information. I remember one a few years ago, I spoke to the employer and he'd said, oh, do you know this person, he worked somewhere else as well for us? I thought, oh, really? So that wasn't in the final statement, was it? You go, what? The lawyer missed that out. And the whole embellishment around exposure levels, I was exposed to constant, unrelenting, massive amount of noise. And you go, no, you weren't, because I know what the workplace is like. I mean, that's just exaggerating. Be honest and state it as it actually is. You don't have to just go, I'm exposed to non-stop extreme noise. Sorry to ramble on. Any questions?
What are some of the weirdest claims that you've come across? I know you've had a lot of buses and bus drivers claiming noise, and you're getting sick and tired of those. They're not necessarily weird, but you've been around the block for quite some time now. So, do any stand out?
Well, the ones with trucks are doing my head in. I'm sick of those. A few years ago, I got so fed up with every truck claim that came. I went through all the noise data one day and counted how many trucks I've done since 1991. It's around about, up to now, it's about 320 or something. So I've measured almost every brand out there. They're really hard to do. I'm meant to be doing one either tomorrow or Friday as well, and the employer doesn't know if the truck's going to be on the road. Oh, you can come down to our depot down at Lonsdale. I said, well, I can, but that's not going to hold up, I said, when I test it idling in the car park. So we need to go for a full run. And it's like, anyhow, they're just really hard to do. And I cringe every time I get one of those referrals. I go, you don't understand how hard they are to organise half the time. So, and especially if the truck's not even in Adelaide most of the week and they're driving line haul to Brisbane and back, or Perth and back, or whatever. So
it's amazing how many truck drivers just happen to have their window down all the time.
Yeah.
They do. Well, there was one infamous one where I thought I did it really well. Every truck I do, where possible, test it with window fully up, down about 5 or 10 centimetres, halfway down, fully down. Usually do it on the passenger side because it's just too hard to reach across. Even if they've got a sleeper cabin, I don't really want to get into it because it's dangerous, when you're not strapped in. It's probably not illegal. That's what a driver said to me last year for one I did down in Mount Gambier, because sometimes drivers drive two up where one's sleeping and one's driving. So it's probably quite legal, but I feel completely compromised from a safety point of view. So I do it on the passenger side and essentially go, well, whatever's on the passenger side is going to be similar on the driver's side, usually. There's kind of complexities around that sometimes, but oh, that's right, this one happened. I jumped in the truck, which was heading off to Neil in Victoria to do a changeover. Sometimes they do trailer changeovers, and then that driver just swaps trailers and comes back to Adelaide, and the Melbourne-based one swaps over and goes back to Melbourne. I thought, all right, I'll jump out at Tail and Bend and get a taxi back. Now, apart from the fact that it cost $270, and I just kind of put that into the invoice without it being kind of itemised. The workers' lawyer, bless his soul, Dante Gloria, said our client drove with both windows fully down during the summer months. And you go, really? So he had both windows down. So Karen Harris from Gallagher Bassett referred it back to me and said, Paul, we need you to go out again. I go, really? You're kidding me. It's no wonder I'm fed up with them. So I jump in the truck again, head up the freeway, and I jumped out at Tail and Bend. Both windows fully down. It was about 90 decibels at left and right ear position because you're getting so much noise buffeting. It's intolerable because you know what it's like with windows down. It's just the buffeting sound that goes on. I've done testing on the freeway actually. It's funny, in my car between Murray Bridge and the Monardo turn-off and done a few loops some years back and wore earplugs because I wanted to see what happens, like left and right ear position. In a truck, you always get more noise at right ear position, even with the windows up, always, unless there's something weird going on with radio switched on or whatever. The buffeting is the key thing, and trucks and cars, aeroplanes, jets, turboprop aircraft, huge amounts of low frequency noise coming through. That's where the dominant frequency bands. But it's really annoying, really, really annoying. I've sometimes worn the dosimeters on big long country runs. I did it to Kimber and back some years ago when I was doing jobs for Viterra over there. And so that was a weird one.
Can I ask a question on that? With the whole truck driver thing and them being enclosed in the cabin and windows up. So one of my clients is a noisy employer where it's noisy, but then peaks of noise as well. So the ordinary noise is noted to be below 85 decibels, but when they peak, it peaks momentarily and then it comes back down to that static amount. So on occasion, and it's been more than a couple of occasions, noise induced hearing loss claim comes in where that person has not been employed there for probably minimum 5 years, and they've been a truck driver for a few years after that, and said, oh, it's not relevant because after that, the driving in the truck, it's all enclosed and it's very quiet in the cabin. And from what you're saying,
well, look, this is where it all gets the game. Who will I lodge the claim against at the point of easiest convenience, really, isn't it? Because how often have I seen a claim where that last employer, one worker claimant says, yes, that was extremely noisy, but someone else who's done the same job goes, no, I'm lodging against the previous one or someone further back. And you go, oh, how come one seems to say one thing and one ex-worker saying something else? Trucks, by and large, most modern trucks are pretty quiet. You know, seriously, if you jumped in a big modern day European truck like a Scania, Volvo, MAN, DAF, Iveco, there's some of the main European ones. They are ridiculously quiet. But as soon as you wind the window down, you get a lot of wind noise coming in. Do truck drivers drive with the window down? Some do, especially the older ones. And most of the Japanese trucks, like Daihatsu, Mitsubishi, Hino, Isuzu, and Nissan, UD is another one. You know, they're pretty quiet. The North American ones are definitely the noisiest, like Kenworth, Mack, Freightliner, Western Star. You know, they're definitely noisier, but they're still not significant if you've got the windows up. But then, what if they turn the radio on? Are we going to worry about radio noises being part of the claim? I tend not to think about that. I just, you know, who knows? I've tested trucks. When I did ergonomics, I actually did my big uni project on truck noise. Ended up going on big runs to Port Augusta and down the southeast and out the Riverland. My sample size was really small, but did some really decent runs and learned a hell of a lot from that. So I just at the time I must have been keen on doing trucks. I'm not now, you know. But yeah, they're complex, and the other complexity about truck drivers is the hours that they work. None of them work 40 hours a week, not unless there's something wrong with the business. Most of them are working 60 plus. Now, as far as how they do their shifts and how much their driving time is versus rest time, and whether they're loading or unloading or participating in that, sometimes I just can't figure it out half the time. You know, I've asked so many employers, how many hours would this person be driving for? And it's like, well, they just estimate it. It's like, I don't know. Most of the time it's probably 60 hours a week, perhaps, you know, including loading or offloading. But truck drivers come up with all sorts of things. I'm exposed to noise from standing near the truck with the forklifts banging and clanging, putting pallets on and off and scraping. And yes, that does happen. But if they're actually within a safe zone from traffic management, they shouldn't be that close. But some transport yards are definitely not that safe, I can assure you, because I've been in tons of them. So, yeah, sorry. Any other questions? Sure.
Well, in regards to, I'll use the example of the dentist. If they're using a device that's 80 decibels, does it make a difference if they're... Most dentists at the moment, when you go in, they're solid walls, solid roof, solid floor, so all can be cleaned down. If that room had acoustic treatment on the side of the walls to mitigate some of that noise, does it make much of a negligible change to the exposure, or is it still pretty much the same?
I think it's really from the right at the tools. I don't really think there's much reflection of noise in the rooms. You know, the one I did a few weeks ago, I had a dosimeter on the dental assistant, and you know, the levels came out at 67, I think. A few years ago I did a SA dental service, and during surgery I wasn't allowed in there. It just made it hard, but you know, I think the average was about 77, and that was only like 40 minutes or something like that. So it's the other thing about dental, which I won't really go into now because it's just too complicated, is ultrasonic noise, because they use ultrasonic scalers. And I guess the issue for some of these claims is whether or not the ultrasonic noise is an issue. I don't think it is, but it's not an overly, I guess, investigated area when it comes to ultrasonic noise. Sometimes ultrasonic noise is terrible. Like if you go down to Hague's Chocolates, they put in an ultrasonic cutter, you know, to cut slabs of chocolate. So I'm not even sure how the actual sonotrode or whatever it's called actually works on an ultrasonic device, but basically cuts through. When they squeal, they're terrible. I mean, you probably know when you go to the dentist, you go, oh goodness, that hurt. You know, at some point where the ultrasonic scaler hits the tooth or hits the gum or whatever, and you go, why do you get variations in the noise? You know, it's hard to measure it because I can't stand there. You know, we can only simulate it away from the patient. So, yeah. But that's another issue. Ultrasonics.
That'll be the next frontier.
Yes. Yeah, I've got some thoughts about that because I've had a look into it. But
I just have one other question, and you might not be able to answer it. Ototoxicity and hearing loss related to that, because there's like you indicated at the beginning of your presentation, there's different ways of measuring hearing loss. How can that be differentiated, like on an audiogram, if hearing loss is due to other things other than, I don't know quite how to explain what I'm asking, but
yes.
Can it be differentiated?
I'm not sure, to be honest. I should know, but it's ototoxicity is when you've got, I guess, chemical substances that cause or contribute to hearing loss. So some chemicals like toluene, which is a solvent, perchloroethylene, which used to be used in dry cleaning industry. So, what was that one? Lead, yeah, definitely lead. And other chemicals, sometimes medications, sometimes cancer-treating drugs, chemotherapy drugs, can cause ototoxicity. So no exposure to noise can cause hearing loss. What happens when you combine the chemicals plus noise? That you might get either, depending on the chemical, an additive effect where 5 plus 5 equals 10, or it might be a synergistic effect where it's 5 times 5 equals 25, so it's a worse effect. It probably depends on the chemicals. Now, there's no way of quantifying how much exposure is too much. There's just no data out there that will tell us. I mean, if you look on the Safe Work Australia and also Safe Work SA websites, actually I looked at this last week, funnily enough, they suggest that you should keep the noise exposure below 80 dBA, so the average noise instead of 85, below 80. And I go in my head, where have you got the data to back that up? They haven't. There is nothing, because it probably depends on the chemicals, and it probably depends on the dosage as well. Just because you're exposed to toluene, if you're above the threshold, like the Safe Work Australia standard for the inhalation of toluene, well, that's a different risk than what if you're at very low level toluene. So, and in combination with noise. So it's a complicated area that no one, I'm sure, in the world has got a proper answer for. I mean, some eminent people overseas who've done a lot of work with ototoxicity, but there's just no guidelines when it comes to, how much is too much. Yeah, it's a good question. So, any other questions?
Not for now, but you'll be sticking around after
I'll be sticking around.
The seminar, so we can
Sure.
ask a couple more questions, and I'll put a couple as well. Look, what I'll do is I just want to ask you all to give for a big loud I should have measured the noise and said, do you need to clap louder or not? And now I want to welcome Oliver Fregnito to talk to you about the ins and outs of Section 18 before Neville shares the stage to take a deeper dive into the Section 18 issues.
Hey everyone, so I'm Ollie Fregnito. I came back to KJK around September last year, and I don't think I've heard a section talked about more. Section 18 seems very popular, so I've been the lucky one to talk about it. So Susanna mentioned at the start that the SA Parliament passed the Amendment Act, bringing in specific sections about Section 18. And in essence, Section 18, if a worker makes an application subject to meeting the requisite criteria of the section, it enables the worker to get an order from the tribunal to direct that worker's pre-injury employer to provide that worker with suitable employment. But now with some further changes that can also be group employers. So it's going to be interesting to see how the amendments actually come into play. I just want to jump ahead to, there's a couple of cases here. I'm not going to go too much into detail, but I think in terms of, managing claims and assessing claims and being in disputes, we're kind of always getting bogged down about the compensability, but I think the kind of something in terms of Section 18, it's really about trying to get the worker back into work and return them to work. There's the provisions that if they don't satisfy, they won't get back into work. But a few of the decisions, especially, I think it was, Morfitt, it kind of spoke about that it wasn't reasonably practical just to say that, there wasn't an actual job available. It was more of, you've actually got to make this job available for them. So if I just go back to the Section 18 and the new Section 18.1, it's quite a mouthful. So I'll just go through it. If a worker who's been incapacitated for work in a consequence of a work injury is able to return to work, whether on a full-time or a part-time basis, and whether or not his or her previous employment, including if the worker has ceased to be incapacitated for work in consequence of the work injury, the employer from whose employment the injury arose must provide suitable employment for the worker, the employment being the employment for which the worker is fit and subject to the qualification in this section so far as reasonably practical, the same or equivalent to the employment in which the worker was working immediately before the incapacity. So the big change there is, the wording of cease to be incapacitated. So previously the duty was linked to the worker having an incapacity for work in consequence of the work injury. Now the duty to provide suitable employment carries on even once the worker has ceased to be incapacitated for work. The decision of Roberts before the changes dealt with this issue of whether it was constrained to the worker having an incapacity for work. And the judge considered that the correct construction of the provision is to provide that where a worker has been injured and unable to work as a consequence, once they are fit to return to some employment, an obligation is imposed upon the pre-injury employer to accommodate that capacity. They went on further to say, once an injured worker ceases to be incapacitated for work, their rights and obligations in respect of any employment fall to be determined under the law governing employment generally, not under a scheme designed to regulate and assist those suffering from a work injury. It follows that the powers created by the section may only be applied in favour of a worker who remains to be incapacitated at the time an order is made. To decide otherwise would extend the right and obligation for formerly injured workers potentially indefinitely. Once a worker had suffered an injury, no matter how trivial or short term, an application could be made under the provision at any time thereafter. The matter went on to appeal, and the full bench accepted that the Section 18 suggested that it only applies to a worker with ongoing incapacity for work. But now with the changes, what does that mean moving forward? Are we going to see more of these applications before the tribunal, and is it going to widen the scope? I think there's the further addition of 4E, which means that it confirms that once notice has been made, it needs to be made within the 6 months of the worker ceasing to be incapacitated. So I think it could even open up more argument of what is cease to be incapacitated. But I think in terms of how we preserve this would just be focusing a need and the observation on a cease to be incapacitated certificate as soon as it's provided by that injured worker's doctor. Now, I spoke kind of briefly about the start about the employer's duty to provide work and in the instances when they won't have to provide work. The main one, we tend to see argued before is whether it's reasonably practicable. But there's now been this addition of CA, being that the worker's employment with the pre-injury employer has been properly terminated on the grounds of serious and willful misconduct, and the onus of establishing that lies on the employer. So before there was no explicit exception covering an employee terminating on the grounds of serious and willful misconduct, but now it kind of gives some further protection to employers if they have. But the onus again is on the employer to show that. And there's been no decisions at the moment, but I think, it's going to be up for the tribunal to determine, what is sufficient in defending an application and what is, enough grounds for serious and willful misconduct. Further changes to section 18(3) and 4, which is more so a process provision. Before there lacked real clarity regarding what procedure a worker needs to make in making a request for suitable employment. And it also meant that there was no obligation on the employer to respond. So there's just a bit more clarity in that, in terms of once the application's been made, if the employer cannot provide suitable employment, they must provide a written response indicating whether they will refuse the worker's request or whether they can provide other suitable employment, and that this must be made within 1 month of receiving the notice from a worker, and then the worker then has a further month to offer any other refusal or apply to the tribunal. Working our way down, section 18(5)A to 5H just widens the scope of the tribunal's power and what specific orders that they can make. They can make orders specifying the nature, range, hours, timing and adjustments required to enable the worker to perform suitable employment. They can make an order as to back pay. They can make orders now in regarding to host employers. And kind of the big one as well is they can make an order for a different member of the self-insured employer group to provide suitable employment. And that's the same as also with any employers that fall under the Crown. Section 18(6), 7, 8, and 9 is just now employers are entitled to their costs, which small win possibly. Beforehand, if it was if the tribunal declined to make an order in favour of the worker, costs could be awarded. But now the employer, not being the compensating authority, can now claim their costs for their involvement in these Section 18 disputes, regardless of the outcome. Section 18(7)A to 7D, this change just allows the tribunal to hear both compensability disputes and now the Section 18 disputes concurrently, and they're no longer being dealt with separately. Section 18(16)A to 16B and 17 deals with labour hire workers, and now that they are protected under the new amendments. So there is now a duty on a host employers to cooperate with the pre-injury employer in offering suitable employment to the labour hire worker, and makes sure that the host employer cooperates and communicates regarding the provision of any suitable employment requested by the worker, participates in any return to work planning, and provides access to the workplace for the performance of duties by the injured worker. But this section also confirms that there's nothing in the Act which requires a host employer to directly employ a labour hire worker following a work injury. Section 18, 16C and D. This kind of what I mentioned before about self-insures and the group employers. So previously it only applied to the pre-injury employer, and now these amendments cover the group employers. So if a worker is injured whilst working for a self-insured employer that is a member of a group of self-insured employers comprised of related bodies corporate, the duty to provide suitable employment applies across the group and is not restricted to the pre-injury employer alone. And this is similar with the Crown. It's kind of hard to, with all of these amendments at the moment to say, how the tribunal is going to enforce this provision. And, it's going to make it difficult for self-insureds to assess the applications of workers making requests, to be working in all these, different kind of groups. But the use of the word related bodies corporate, I think, kind of presumes that those related bodies corporate share a management structure, which would hopefully make the movement of the employee, if they were ordered, semi-streamlined. So you're not kind of getting a worker doing something that they've never done before, but we'll see what the tribunal says. This is the kind of the last amendment, and this just deals with the the issues of back pay and it's a new provision confirming that back pay orders do not constitute designated weekly earnings. So that's kind of just a big helicopter view of the actual amendments that have come in. Like I said, it's going to be interesting to see how the tribunal deals with these. But I'll pass on to Neville, who will kind of go into a bit more detail himself.
Thanks, Ollie. While I've got you as a captive audience, I've left some flyers out the front there. When you have your drink, pick one up and help fund my son's fringe show. Just across the road at the Chateau Apollo, if you like Adele. It's and great harmonies. Read about it. It's meant to be really good. Better be. And help struggling artists. I titled mine "Has Section 18 turned into a sovereign citizen?" because I think that the state government is extending its powers a little bit far, and possibly there'll be some constitutional challenges to these new provisions. There was a sort of an attempt under under the previous Section 18, and many of you would know the case of Walmsley, which was essentially the pinnacle case under Section 18 that Judge Hannon decided back in 2016 now. The challenge was, is Section 18 really trying to usurp the Fair Work Act, particularly if we're talking about Commonwealth employees here, which covers the field for unfair dismissals and reinstatement of employment. If you're familiar with the Commonwealth Fair Work Act, and even the State Fair Work Act, an employee may seek reinstatement as a remedy. And basically what Section 18 is doing is saying, well, the tribunal can order a reinstatement, and that is technically really allowing a state power to override a Commonwealth power. So there was a challenge about that, but then Judge Hannon was very clever and said, oh, look, Section 18 actually deals with rehabilitation and return to work beyond just compensation, so that gets it around the constitutional issue, and that was accepted. Didn't end up in the High Court, and I think it was accepted because then we had these subsequent cases, that one of them that Ollie referred to, such as Roberts and Coleman Sleep, where the tribunal said, well, look, if you've ceased to be incapacitated, then Section 18 doesn't apply. And I think everyone sort of said, okay, well that's fair enough, we can live with that. And then we just argued the merits about, was it reasonably practical to have the worker back? However, now what we've got is the new legislation saying, well, it doesn't matter if you've ceased to be incapacitated, you've still got a right, as long as you've had a claim at some stage in your life, you can lodge your 18, but with that provided that it has to be within 6 months of ceasing to be incapacitated. So I think what we need to do is take a survey today, and whoever wants to be the first one to challenge this and take it to the High Court, put your hand up. We're happy to act for you. So we have this the 6 month danger zone, which is where obviously if a worker has still got an incapacity for work, they can bring their Section 18 application. I'll get to that a bit later. But if they have ceased to be incapacitated, they can still bring the claim or an application to keep their job, be reinstated to their job. Now, we would have situations where a worker's fallen off the system after 2 years or 3 years with the medicals, and then employers ring us up and say, can we get rid of them? We don't really want them anymore. And I can say, well, depends. If they've still got an incapacity for work, they're no longer on a compensable claim. Are they fit for the inherent requirements of their pre-injury job? If the answer is no, then we can go down that avenue, get some medical evidence, support the inherent requirements argument, and generally successfully terminate without too much risk of general protections or unfair dismissal claims. In a case where we now have workers that have ceased to be incapacitated that can still apply, that makes it a little more complex. So the first question is, when have they ceased to be incapacitated for work? Is it going to be based on a worker's doctor's certificate, or an independent doctor's certificate or report? What if there's a conflict between the two? Or is it going to be based on a Section 48 determination being issued? Or what happens if there's no 48 determination but the worker's just returned to work? They're doing their full pre-injury duties, full hours. There's never been a formal determination, but informally they've returned to work. But there's nothing in writing. When will the 6 months run? That is going to be a subject to dispute, I'm sure, at some stage, and hopefully the tribunal will qualify that for us. So really, I think, as Ollie's already mentioned, the safety measures during this danger zone will be to keep track of workers as soon as you've got a certificate saying cease to be incapacitated, knock up your 48 determination ASAP, get it out to them, then you've got a line in the sand in case there is an application that follows. What about terminating within 6 months of ceasing to be incapacitated? Again, if it's for serious and willful, shouldn't be a problem. If it's for serious performance issues and they've fully recovered, I think it's probably okay. Not 100% risk-free, but certainly if you've got a really good case, you're treating these people like anyone else, whether they've had a claim or not. And if they're just not performing and it's got nothing to do with their previous injury, then you should be okay. I think we're going to get complications when it comes to site claims, because they might assert they've re-aggravated or exacerbated a previous claim because of performance management. Gets a bit messy again. Forced redundancy would be a problem. First of all, they may say they've been targeted because of their previous claim, but ultimately, if they're forced off the system or forced off your employment within the 6 months, then they might lodge an 18 application and try and circumnavigate or circumvent your termination anyway. Voluntary redundancy, not a problem, as always, and any non-work related injury or illness that results in long-term absenteeism, that should be fine as well. But again, look, I think within that 6 months period, we just have to be very careful about who gets terminated and why, and obviously seek advice if need be. Yeah.
Sorry, can I
Sure.
ask a question? If they're casual,
Mm-hmm.
Where does it sit with that? Once they've been ceased to be incapacitated, can they not employ them anymore? Are they cut?
Yeah.
What is that?
Well, in normal circumstances, you would say, yeah, of course. If they're a true casual and they haven't, and by that I mean, it's not a systematic and regular employment cycle. I've seen many casuals, in inverted commas, that work, 38 hours a week, or every Monday, Wednesday and Friday, 8 hours a day. That's not casual. Doesn't matter what you call them, it's not casual. So if we've got true casuals that are just on call, that can reject work when they want to, are offered work when the employer wants to offer it, and you can see there's not a regular established pattern in their employment, then you would treat them like any casual. However, I think we've still got that 6-month danger zone. So,
You're in danger, girl.
yeah,
Again.
yeah. We're in Top Gun territory. So, yeah. Any other questions on that before we move on? Nope.
Just,
Yep.
Can I just ask, with the cease to be incapacitated, so if we get, say, a full clearance for somebody, that's not enough. So we have to write to the doctor potentially and just ask the question about whether they cease to be incapacitated?
Well, yeah, that's the difference between being fully cleared to return to work and ceasing to be incapacitated. So we really have to have that tick in the box that this worker has fully recovered, they have no incapacity whatsoever for work, so not just fit for full hours and full duties, but with a slight modification or whatever. A lot of doctors, I've seen, a lot of GPs don't really understand how the WCs work, and they'll tick them off as cleared, but then in the back part they say, but, be careful, don't bend, don't do this, whatever. So that's not ceasing back. So yeah, it's better to get it firmly in writing, whether from the GP or from an independent at least, so you've got something to rely upon. Then you issue determination, and hopefully it's not disputed. So, yeah.
And because at times we'll issue a closed period determination, so is that maybe technically incorrect? Should it just be ongoing until such time as we can terminate an entitlement based on clearance or cease to be incapacitated?
Well, the closed period has to be based on something. If you can accept it for a closed period on the basis that you've ceased to be incapacitated as at a certain date, that's great, and the worker doesn't dispute it, then you've got that in writing and there's no issue there. They'd have to put a new claim in for any new period off work. But if you just accept it for a closed period because they then returned to work in inverted commas, so they're doing their full hours, they're not getting any income protection, any income maintenance at the time, that doesn't necessarily equate to being ceased to be incapacitated.
No, that's right.
Yeah.
So then it,
Section 18.5 now allows for employment with associated entities, so those of you that are big enough, or if you're in the Crown, look, basically, if you're the Crown, there's no hope, right? So, really, this topic's irrelevant to you guys. So, it's too big, there's too many different agencies, and a worker will just say, or the tribunal will just say, look, okay, you can't go back to Department of Health, but you can go and work over in Treasury or whatever, doing admin. Yeah, go to it. So yeah, there's not a great deal of hope there unless you can mount an argument under the exclusions under Section 18. Those of you big enough in the private sector that have associated businesses, the tribunal has to make the order for you to go back to work. Do you want to ask a question now or before we...
Oh, no, we were just talking about if, say a worker goes on a 6-month contract, we're government, so
Yeah.
they get a 6-month
you've got no
contract.
hope.
So they get a 6-month contract with education or something,
Yep.
and it comes to an end, and of course we get them back, we find another work. Can the worker lodge a Section 18 to say they can continue to work in education, because that role's there, they've been doing it?
Potentially. Why not? Yeah.
Yeah.
Yep.
Particularly if there was evidence. I think in that situation, if there was
Because
evidence.
it's often a backfill
Mm.
Yeah, look, I know how complex it is for you guys in government. But I reckon if they've got a doctor saying, well, they can't go back to, I don't know, Treasury and Finance because they had a stress claim there, but they've been happily
Yeah.
working over doing
Yeah, I
6
know.
months in education, and they want to stay there, I reckon they could push the envelope.
So
here.
education's got to find them a position. And do they
Potentially.
have
I
to
reckon that could happen now.
Yeah.
Yeah.
Yeah, what right do they have to push back? That's the thing.
Well,
I think it comes down to that regional practicability.
you'd have to show
argument,
there's no
but-
position available, or you'd have to sack someone to make room for them, or they can't work.
Yeah, I know, that's what I'm
Yeah.
just saying. Is,
Well,
a
this
lot
is,
of people do
yeah.
short-term contracts and they come back to us and we put them out somewhere else 6 months
sure.
contracts.
Well, I think with stress claims, like bullying and harassment, which we see every day these days, something like that, if that arises from the department they were in at the time, then I think there's a reasonable argument to say, well, you can't go back there, right? And they may not want to, but they'll.
Yeah.
But this is for an order from the tribunal. It's not a decision that the worker can push on us, for no reason. So, so the tribunal has to make that order. So again, I think, particularly with the private sector, if there's going to be orders made that a worker is to be re-employed but in a different entity, which may well have different enterprise agreements or different awards that cover them, could be different hours, all sorts of different terms and conditions. I think that's starting to push the envelope a bit again constitutionally as to the power the tribunal has, because I think it's going beyond, rehab and return to work. Yeah. So again, that could well be a topic of dispute and potential challenge by a brave employer. What about if the worker is terminated for serious and willful or resigns post incapacity? Section 18 deals with that. They say you can't have a claim. But I wonder whether workers' lawyers might try and, again, circumnavigate that and say, well, that only applies to the pre-injury employer, and the worker wants to have a job in a different department or a different entity, and therefore that doesn't apply. I don't know how far that'd get, but it might be worth a bash by a worker to give it a try. How much to pay and for how long? I think the tribunal can only order average weekly earnings rates and re-employment for the effect of basically for the 2-year designated periods. After that, I think if a worker falls off an entitlement to weekly payments, then you probably have to look at whatever the substantive wage would be for the position they're working in at the time. And if that means they're getting a higher wage than their average weekly earnings, you might have to wear that, because you don't want people working in the same jobs for the same employer, same hours, getting different pay rates. That's not going to go down well. So again, another complication that we haven't really explored how that's going to pan out, but that's something to be considered.
What happens in the event that a worker also ends up getting terminated and now has lodged a Section 18 application with the tribunal, wants to be reinstated, and then there's a discrepancy, and in the meantime his or she has been also earning money elsewhere? What do you think would be the likelihood of them getting the average, the AWE's paid compared to whatever he or she was earning in the meantime?
That's an interesting one. I hadn't thought about that, because if they're working elsewhere, you have to question why they'd lodge the 18 unless they just not getting paid as much. But then I guess it comes down to, is it reasonable for an application under Section 18 to be made when a worker has clearly got capacity for work anyway? But ultimately, I guess if they said, look, I want to quit my job and come back, and the tribunal agree with it, which I think in that situation they may not, but if they did, then that whatever the substantive wage is for that particular job is pretty much what you'd have to pay them, I would have thought. But again, that's starting, it gets into industrial law and law covered by the Fair Work Acts, plural. So it comes back to my first concern, has the state really gone rogue here when it comes to what it's trying to do? As Ollie said, you don't even need an accepted compensable claim to bring a Section 18. Again, that's it's a very brave move. So what that's going to mean, I guess, is that with a rejected claim, the worker might dispute that, and at the same time they'll put in a Section 18 application. And now that they can be heard together, that I imagine will be the par for the course, because then the tribunal can decide both the question of incapacity and then the question of reinstatement to employment that either the worker has nominated or the tribunal thinks could be suitable for them, even if the worker hasn't thought about it. So very broad powers to the tribunal. And finally, we would normally be able to, as I said before, we talked about the inherent requirements, whether you could terminate. Normally the answer would have been yes. So I think, again, we just need to be very cognizant of the fact that it's not going to be as easy as it used to be to terminate for inherent requirements, because the tribunal again could say, well, look, yeah, we agree the worker isn't fit for their substantive pre-injury position, but they're fit for a different position in a different entity, doing different hours and different days, and pretty much invent whatever they want to fit into a particular job. So again, extending powers extremely further than there have been before. So watch this space, I think. If you do get in a position where you want to terminate the worker that could potentially come under the new provisions, try and settle it as soon as you can. Deed of release, so there's no comeback under Section 18 or any other industrial provisions. Yeah. Thank you. Any other questions?
Someone's on probation.
Are they?
If they are,
Yeah.
what happens? Like, there'll be one worker that we may be moving on, whether before he's cleared or not cleared. What happens with the probation, even if he
Still at
say
work?
he's cleared, ceased being incapacitated, and they want to get rid of him because they can, and he can't go to unfair
Yep.
dismissal. What happens with that?
Well,
under
he's got
Section 18?
the magic of Section 18 now, so he doesn't need the unfair dismissal jurisdiction.
So we extend the probation first.
No. Well, it won't matter as long as they're working. It doesn't matter if they're under probation or they're past probation. The fact is they're at work, they have an injury. So they obviously, if they're incapacitated, they're still going to have a right, regardless of the probationary period. And now, even if they've ceased to be incapacitated at, 5 months, they're still going to have a right. So, I would have thought that the shorter the period of employment, the harder it's going to be for them to say, I want a full-time permanent position, if you can show that they would not have passed their probationary period. Right? So you'd have to say, look, this person was under review, we were going to meet with them a week before their 6 months was up and tell them, look, you're just not suited to the job, you're not performing well, whatever. That all comes into play when we can have our reasonable defence. All right, we better keep on moving because we've got a fair bit to go. Tracy's going to give us some case updates.
This is my clicker. Hi everyone. I'm gonna do 2 cases, then Chrissy, wherever she is. Oh, you did go and sit up the back. She's the naughty one. She's got to sit up the back of the bus. And Chrissy will do a couple. There haven't actually been a lot of cases coming out. The tribunal has really slowed down. A lot of the cases aren't in necessarily our jurisdiction. So they got plenty of work, but isn't necessarily all workers' comp. And I'm going to talk about two cases. One relates to costs, and the other one's noise-induced hearing loss, my absolute favourite topic, as you all know. Mr. Al-Sharida, this is not his primary case, this is the subsequent case about his application for costs, and there was also application for costs by Return to Work SA. In the primary claim, Mr. Al-Sharida did not do well. One of the rare cases where a worker at the tribunal lost. He pursued a claim for various injuries to his body, which he says occurred at work as a result of a fall in April 2018. The fall was never reported, never witnessed, and he didn't make the claim until June 2021, so quite a long way down the track. And he didn't tell any doctors about it. So didn't tell the employer, didn't tell any colleagues, didn't tell any doctors, but he had this massive injury. And he also failed to disclose that in his home country, which I think was Iran or Iraq, I think he was a refugee, he had had a massive traumatic brain injury. So he didn't tell anyone about that, and that obviously would have had lingering effects. So he was not found to be in any way credible. The judge actually described him as having lied, deliberately admitted parts of his medical history, embellished or changed his version of events, and presented such implausible explanations of discrepancies that his evidence lacked credit. So basically, he was a liar and a cheat. I mean, that's the basic. Well, you know, that's the the nice way of saying it. But he lied about pretty much everything, and that was the finding of the judge in the primary case. So then they had to have the fight about costs because, as you know, generally when you're on the employer side of things, win, lose or draw, generally the worker gets their costs, but there are certain exceptions, and this was one of them. Sorry, just get this to work. So section 106.3 says that the SAIT can decline to make an order for costs if a party acts unreasonably or frivolously or vexatiously, either in bringing the proceedings or during the conduct of proceedings. And they can make orders for costs, they can decline to do so, or they can reduce the amount. And this is basically what happened in this case. There are very rare cases where workers don't get their costs, but historically the ones where they don't have been in this category, where a worker has been found to basically almost be fraudulent. So that was the issue. Was it reasonable for the applicant to be awarded costs against Return to Work SA, and Return to Work SA was making its own application against the worker? The judge said the worker must have known from the outset that his claim was unreasonable. He wasn't entitled to costs against Return to Work SA because his conduct was so egregious. So it's a pretty high bar to overcome, but in this case, unfortunately for this worker, the judge found that the hurdle applied. Then the issue came as to whether or not Return to Work SA should get costs against the worker, and they did make it an application. They never put the worker on notice as to costs in the lead up to the trial, which actually impacted on the judge's decision-making process because in the end, I think it was Judge Kelly, found that by not notifying the worker as to costs, that may have impacted on his decision to proceed because he presumably may have been getting advice from his lawyers that, win, lose or draw, you'll get your, inevitably you'll get your costs, so you'll be fine no matter what happens. So the judge made an order in favour of Return to Work SA, but only for 50% of their costs, even though the likelihood of Mr. Al-Sharida actually being able to pay them is quite low. So I thought that was interesting, her comments about not being put on notice as to costs. So the key takeaway is that it still remains the case. It's still a high bar for a compensating authority to overcome the usual tendencies of the tribunal, which is that a worker inevitably gets their costs, but there are certain cases, and clearly fraudulent behaviour is the prime example where that will occur. Putting a worker on notice as to costs should be done at least prior to trial in order to produce your best outcome in these in cases where you suspect that this is the case, that you think this worker is fraudulent. I wouldn't recommend that you do it in every case, because otherwise you're just the boy who cries wolf. You know, Tracy Kerrigan, every time when she's going to trial, puts the worker on notices to cost regardless. That's probably not going to be an argument that will work. But if you genuinely believe that the person who is pursuing the claim might fall into this category, I think it is a good idea to put a worker on notices to cost, so at least you can say to the judge, well, we warned him. We gave him the opportunity to, you know, walk away, maybe even make an offer, or bear our own costs, something along those lines that you can then say to the judge in the argument about the costs at the end of the day. If you are successful in those very rare cases where this happens, that you've got an argument that you should get an award of costs. I mean, Return to Work SA was putting forward arguments about, you know, it's a deterrent to other workers, you know, if an award is made. And that's a strong argument, you know, because, you know, if the word gets around the industry that, you know, there are times where workers don't get their costs. Workers' lawyers, hopefully, might be a little bit more circumspect in what they tell their clients. Because I suspect in most cases, they simply get told, you'll get your costs. And I mean, I say that to my clients all the time. Like, you know, when you're looking at cases, well, you know, the likelihood is you're paying both sides' costs when you go to trial. And that impacts on people's decision-making process. So that's quite an interesting case in terms of costs, but it does demonstrate that issue of it is a high bar to overcome, the usual discretion. Any questions? I just put it in because I like to. I just thought, Mr. Al-Sharito, you're really we're not telling the truth. My other one is my noise-induced hearing case. It's a very recent one of Judge Caligaris, of Mr. Holberton and Tasmere. He put in a claim for noise-induced hearing loss against Ottaway Engineering, which is a subsidiary of Tasmere, which is a self-insured employer. He had been employed by them as a manager from August 2012 to August 2016, mainly working in the office, which was adjacent to the workshop, occasionally going into the workshop to talk to colleagues, staff, whatever. He then left and worked for a company called EcoSpec for about a year. He then was basically self-employed by his own business from January 2018 onwards. The sort of work he was doing for both EcoSpec and Tube Solutions was basically the same. Wasn't the type of employment that would expose him to noise. So he made the claim against Tasmere or Ottaway Engineering as the last noisy employment. He was still basically working, so he hadn't retired. So he was going to get the benefit of the presumption in Section 9 that the last noisy employer has to discharge the onus of proof that rests upon them. He provided an affidavit of evidence about his alleged noise exposure prior to Ottaway Engineering, his alleged exposure at Ottaway, and his alleged non-exposure at the two subsequent employer and self-employment companies. Dr. Fagan was giving evidence for the worker, Dr. Tomrich for the employer, so it's like, you know, an array of all the usual suspects. Ottaway Engineering called a colleague of his to give evidence about the level of noise in the workshop and the number of times that he would have gone into the workshop in the normal course of events, being a manager, so he wasn't in the workshop all the time. The judge identified a number of factual errors in the witness affidavits, and there were several in both the workers and the employers, and this all had to be dealt with in oral evidence. The problem was it also meant that it carried over into the expert reports because the factual errors or the history being provided to the doctors was clearly not accurate, and we come across this all the time doing noise-induced hearing loss claims. Susanna and I have been working on one, and the one I settled yesterday was the amount of information that has come out since the conciliation conference, since the first affidavit of evidence. We're on for trial on Monday, and we were going to get another affidavit from the worker about what he was doing since he left, our employer. So this is very common, and I'm sure you're all experiencing it too, for matters that aren't settling, that when you're going to trial, you're getting, you know, what they tell the doctor initially when they go and see Dr. Fagan or Dr. Tomic or Dr. Haynes or whoever, and then what comes out in the affidavit, and then the supplementary affidavit, and then you query them, the medical notes, and then something else comes out, and what you end up at the end is quite different to what you started with. And the judge was highly critical of this problem that was demonstrated in this case. So the judge confirmed the legal fiction that Paul was talking about. The worker has to prove that he has noise-induced hearing loss and was employed in work involving exposure to noise. And the judge in this case was actually satisfied that the worker had noise-induced hearing loss and that there was a potential for there to be noise exposure because of the noise in the workshop. The burden of proof then shifted to the employer to refute that assertion that the hearing loss did not arise from their employment. As I said, the worker proved that he had noise-induced hearing loss, and that was based on the medical evidence, the frequencies. Those of you who read reports about noise-induced hearing loss all the time know that the ENTs tend to identify noise exposure and the damage that it causes at the higher frequency. So 2,000 to 4,000 is the norm. Can be lower frequencies for people who have been exposed for many, many years, particularly in very, very noisy industry. But generally, the science is 2,000 to 4,000. He proved that he had that. He also proved that the subsequent work was not capable of causing noise-induced hearing loss. It was basically office-based. But Tasmea successfully discharged their onus, which is also quite unusual because most of the cases, the employers don't tend to successfully discharge the onus. And there's, you know, a couple of cases late last year that are examples of that. One, both involving Viterra, one where they won and one where they lost. So it's all about the evidence and what evidence was led. So the evidence of the colleague about how often he went into the workshop, what noise protection was available, what they were actually doing in the workshop, and he was spending pretty much 90% of his time in the office, not in the workshop. So the judge, look, I don't think the judge was particularly impressed with how the case was run. That's the vibe I get out of it, because he was so critical about the affidavits. But ultimately, the factual evidence and Dr. Tomic's evidence was that the exposure at Ottaway was insufficient to cause noise-induced hearing loss, even though he was being exposed for about 90 decibels of noise between 1 and 2 hours per day whilst wearing hearing protection. But then he worked in a quiet environment for the rest of the day. So I guess that's that issue that, Paul, you were talking about, is that intermittent.
These drive me mad.
Exhibit A!
It's almost identical and it's in dispute. And what I did, I set up the meter in the office, I wore one, and randomly walked the workshop to try to simulate it, because there's no other way of doing it.
Yeah.
Actually, funnily enough, Dr. Thomas rang me about this one.
Oh, I'm not surprised. Yeah. There were a number of different reports from Dr. Tomic and also from Dr. Fagan, as the evidence wound its way through from one affidavit to another. But like I said, the judge was highly critical about the standard of the medical reports and the lack of proper factual evidence and history being provided to them. So if you have any cases and you're looking to, that you're not satisfied, be very careful about the evidence that is being led. And Susanna's fascination with dentists is because we've got one going to trial next week about dental nurse. She's a dental nurse, isn't she? Dental assistant. But yes, every time it comes up, I'm like, yeah, because when you go to the dentist, like, you know that noise wears for a while, but then it stops because they're doing other stuff. Anyway.
But I've also had so many flashbacks to my sort of childhood, getting into those dental clinics where you got the radio cranking, you got, the cool vibes, sitting next to multiple people. Anyways.
We're very obsessed with dental assistants in the office at the moment. So look, if it runs, we might get a case, we might get a judgment. But the Holberton one is quite interesting because of the employer successfully discharging their onus, because it's not an easy thing to do, I can assure you. Sorry? Shocked to hear that, yeah. I haven't seen this. This is new. I didn't see it. I saw the earlier version. Sorry. The Willy Wonka photo. I missed that. So our key takeaways from Mr. Holberton is reviewing your affidavit evidence compared to the probably very brief history they give to Dr. Tomich or Dr. Haynes or whoever when they first see him. Oh yeah, it was real noisy. Seek supplementary comments from your experts as early as possible after you receive the worker's initial affidavit. And if you've got any concerns about inconsistencies between that and the history they've originally provided, as well as any other factual information that you have from your witnesses, whether it's about the level of exposure, the equipment they're using, the amount of time that they say they're being exposed to noise. These are all things that really need, to use the expression from the previous thing, a deep dive in order to, otherwise it is extremely difficult for an employer to discharge that onus. So it does require careful review. So that's my 2 cases. Any questions? No, otherwise I will hand over.
Not related to
Oh, sorry.
Sorry,
Robin.
Where the worker has lost their hearing aids.
The lost hearing aid, yes.
89 years old. And you've spoken about this before. What is the obligation to then replace them?
Well, I mean, it's whether it's reasonable to do so. I mean, if they lose it within 5 minutes flat of getting them, I don't think it is reasonable. Yeah. And Judge Kligeris kind of verbally in a judicial settlement conference made a similar comment. But, you know, if it's a case of, you know, it's, you know, been 4 or 5 years and they've lost them, and then you're coming up close to the 5 years anyway, it's probably more reasonable to replace them. I think a lot depends on the history. Like if they've always, I mean, I had a series of ones with the old guys taking their masks off during COVID and the hearing aid going with it, and I looked everywhere, couldn't find it. Yeah, so I think every case comes down to the facts. Like, you know, if they've, you know, lost several before, and, you know, and I had one guy, I think he lost 3 in a row within a really short space of time. By the time we got to the 3rd one, I'm like, no, mate, you just...
Selling them on the black market,
yeah. Or jumped in the swimming pool with them in, you know, that sort of, you know, negligent behaviour. I think it just comes down to an assessment of facts and where they are in their claim, and how they say they lost them. And if they've done it, you know, if it's something they've done regularly, or whether they're just, this is a one-off and they've always been really good with them and been real careful. So, okay. Oh, this is you. I'm thinking, no, that doesn't look familiar.
Thank you.
No worries.
Okay, I know I'm standing in the way of drink time, so we'll get the 25 words or less version. Why I wanted to talk about Hussein 1 and 2 was because it's just indicative of a period of time we're in at the moment where we're seeing more and more applications being made trying to direct workers to attend medical appointments. So the facts in this one here are such that effectively Mr. Hussein has made an application to be taken as a seriously injured worker under 21(3) on an interim basis, with a series, as you can see, of what I call and here syndrome. So right shoulder, left shoulder, right hand, wrist, xerostomia, deglutition, obviously your medication-induced injuries, liver dysfunction, CRPS is in there, right shoulder, the neck, the back, the right bicep. There's not too much of Mr. Hussein's body that's working really well at the moment, unfortunately for him. So what's in dispute is what is in dispute is essentially the rejected 21(3) application. So they're the SAIT proceedings. And as part of that, Return to Work SA was attempting predetermination of the 21(3) application to get Mr. Hussein to see Dr. Champion. Now, he refused, and by way of that refusal, they were forced to make a decision on the application. As part of all of the other injuries, he's claiming to have suffered from sleep apnea as well. These all result to... Sorry, someone laughed. all said to have occurred on the 1st of May 2020. He's also thrown in his site claim for good measure, just to make sure we've covered off on everything. So I've said that the respondents rejected the application. And as part of the proceedings, this is where it all begins now in terms of the interlocutory applications. So an application for directions was put on by the compensating authority seeking an order that would require the worker to attend a medical examination arranged by them with Dr. Champion for the purposes of confirming the diagnosis of CRPS in accordance with Chapter 2.22 of the IAGs. So the long list of injuries were not all compensable injuries. If I'm not misleading you, I think the original injury was a right shoulder, which was accepted. The rest are mostly in dispute and consequential injuries. So as part of confirming diagnosis, which you all know is really important with CRPS, they wanted to get him off to have the examination with Dr. Champion. Now, the resistance has been incredible. It covers things about whether or not it's in the interests of justice that he attend. And the applicant went as far as saying that there was neither an express or implied statutory power vested in the tribunal to make the order. Knowing I suspect that they were going to fail because there was statutory power, they said in the alternative, the worker argued that the tribunal did have the power if they did have the power to order the examination, jurisdiction couldn't be exercised where the object of the assessment was to seek an opinion as to the permanent impairment where the worker had already been assessed in accordance with Section 22 of the Act. Now, Dr. Siaptu had undertaken a whole person impairment assessment. So that's the rather convoluted aspect of it. There are compliance issues that the corporation is attempting, obviously, to bring out in terms of the Siaptu report, which is why, of course, the interim seriously injured application was made. So Deputy President Judge Rossi said there is an implied power conferred, and that power comes from the SAIT Act, Rule 213 of the rules, was a valid exercise of the rule-making power conferred by Section 92 of the SAIT Act. And he went so far as to say that the onus is on the party seeking the examination to persuade the tribunal that its intervention is reasonably required in the interests of justice. As with most Judge Rossi decisions, he likes to really teach us and specify exactly what some of the things we have to take into account are. And important to just have regard to the fact that this list isn't exhaustive, but obviously whether the compensating authority exercised power conferred by 31 subsection 2 of the Act to have the worker examined prior to the determination of the claim, and if it did, whether there has been a material change in the circumstances so as to require a further examination. That's a big one, which I'll touch on right at the end as well. But important to remember for Mr. Hussain that he refused to attend pre-determination. The issues to be determined at trial by the tribunal and whether the examination requested is reasonably required. And that's for the party to be able to properly present its case. That's touched on in number 2, which we will see. Any likely adverse impact upon the worker if the examination is to proceed, the nature of the examination to be conducted, and the reasonableness of the arrangements made, including the date, time and location of the scheduled examination, and the identity of the proposed examiner. It's been a long time from a personal perspective that you've seen the latter pop in there in terms of the identity of the proposed examiner. And I suspect it's probably because in dealing with the 21.3 application tied in with the 22 assessment, the point the judge is trying to make there is in terms of whether the examiner is properly accredited or otherwise. So I don't read too much into the identity. In consideration as to whether the compensating authority was able to seek an opinion pertaining to Chapter 2.2 of the IAGs, His Honour considered the decision of Clayton Church Homes. This is being referred to in a lot of decisions at the moment. It's Orfanu. It's a decision of Judge Caligaris. And he said there that there may be a relevant diagnosis for the purpose of verification by more than one examining physician outside of the 12 months leading to the permanent impairment assessment, but the requirement that the diagnosis must have been present for at least 1 year relates to the 12-month period immediately prior to the assessment. Now that's specifically for the CRPS that they were asking Dr. Champion primarily to look at. That's the big ticket item in terms of the 21-3 application. His Honour concluded that the worker should be required to attend the scheduled appointment with Dr. Champion in relation to the claimed injury of CRPS and was directed to cooperate with the examination process and not hinder it. And that was because as part of the application, the applicant tried to really pick apart the compensating authority's referral, the commissioning letter, to try and take out again some of the very important questions dealing with the actual diagnosis of the CRPS itself. They're effectively trying to make sure that despite having an assessment of the CRPS by Dr. Siaptu, that the question of causation was not to be an issue, if you like, because it had almost been done a bit back to front. So the key takeaway of case 1 is whether the presidential members of the tribunal will ultimately exercise their discretion, because we know that they have it, to make an order that someone attend a medical examination, and that will depend on whether the party seeking the examination is able to persuade them effectively that their intervention is reasonably required in the interest of justice, and it will be determined on a case-by-case basis. Okay? That's not new, that's not unusual, that has effectively always been the position when they are deciding these applications. It didn't end there, for obvious reasons. Mr. Hussain is doing whatever he possibly can to make sure that he tries to not attend Dr. Champion's rooms. So they filed a notice of appeal against Deputy President Judge Rossi's order, as well as a further application for directions to stay his order. So what that meant in terms of the timing is by way of Deputy President Judge Rossi not being able to hear the application for directions immediately, the President was given the application for directions and he made an interim order staying the operation. So effectively, that meant that the applicant was not required to attend. He did that, again, on an interim basis until such time that Deputy President Judge Rossi was able to hear the actual application for directions. But of course that meant that the November appointment that had been made with Dr. Champion had disappeared, that had to be cancelled. So effectively the respondent then made an application seeking an order that the applicant attend an examination to be performed a couple of days ago in February.
Did he go? Do we know if he went?
Don't know. But the appeal was heard. The appeal was heard. So I'm not sure what the outcome of that is as yet. So effectively, again, in terms of what happened on the application, Judge Rossi effectively said there was absolutely no utility in revisiting his order, which was forcing the worker to attend the November appointment, because of course, by virtue of what had happened in the circumstances that had been and gone. So they were focusing on the February appointment. Again, he confirmed that the respondent had the onus of persuading the tribunal that the discretion should be exercised in its favour. That discretion conferred should be exercised to require the applicant to attend. And it was reasonably required as part of the respondent's preparation of its case to be presented upon the hearing of the substantive proceedings. He said that outweighed any likely disadvantage to the applicant. And I'll just go back and sort of hash that out so that it actually makes sense, even though I said I was going to give you the 25 words or less version. And in doing that, I'll take you back to, oops, too far back. That slide there. Because effectively the compensating authority was trying to get back to, so they were asking Dr. Champion to consider causation in terms of confirming diagnosis, first and foremost, and causation, and then providing the long list of all the injuries, obviously his opinion as to whether or not there was any merit in their rejection. So what was going to be his overall indicative assessment on the 21-3 application. So Judge Rossi grabbed onto that point and effectively said that it was not disadvantageous now for the worker on the basis that they had effectively now indicated that their case at trial on the 21-3 application was going to be two-pronged effectively. With confirmation of diagnosis to make sure that that was consistent with what the IAGs say, and also then effectively all of the other issues that come up in terms of the CRPS and from a causation perspective beyond the diagnosis. So in considering all of those things there, he was able effectively, I guess, to determine that it was reasonably required in order for the party to be able to properly present its case. So we're not directing that the worker attend, he was in fact going to be prejudicing the compensating authority. And you all know that doesn't happen too often in terms of being an active consideration for us. So that's why I thought it was important, because again, a lot of these applications, as you know, we try to organise independent medical examinations because for whatever circumstances, we haven't been able to do them pre-determination. And we all know, you know, the firms which challenge us on that and then say, no, the worker's not going to go. So we end up going down this path. And a lot of the judges are not sympathetic to us in that respect because, again, we have the power from an investigation perspective to conduct a thorough investigation, which, you know, we can get a couple of IMEs in, truth be told, if we needed to, particularly if you had a long shopping list of injuries like Mr. Hussain does. So in circumstances where we haven't been able to do that, trying then to get someone to go along to the appointment, as you know, is really, really difficult. But I think we've come a long way away from the very basic applications and affidavits whereby we're simply saying we want the tribunal to exercise its discretion and make that order. I think now, effectively, what Judge Rossi is trying to tell us is we have to give consideration to all of these issues and really outline why it is that we need it. So is it a differing opinion between Dr. X and Dr. Y that perhaps a third doctor is going to be able to comment on? Or are we doing what we're always accused of doing, allegedly doctor shopping? We don't like Dr. X's opinion, so we're trying to get Dr. Y's to, assist our case. And in those circumstances, if we're not able to convince the presiding members that we're not just doctor shopping, we fail. So that was why I thought it was important to sort of put this one on the list and just highlight, because we are seeing more and more of these applications to get the doctors to go along, to get the workers to go along to these appointments, but more so on this issue now of the CRPS. So clearly, if you look at, so Jared Warren was representing the applicant in the circumstances, and if I'm not mistaken, it was Simon Hannes together with Mr. Roda for the compensating authority. So you could tell that the stakes are clearly high in terms of defending the 21-3 application, and clearly the CRPS is the big ticket item there insofar as that will be a high assessment. And by the time we do the building blocks on all of the other shopping list of injuries, it's not going to be too hard. You would have thought, if they are legitimate injuries, for Mr. Hussain to get to that 35%. Yeah.
And we've definitely seen people, particularly those who have CPR, they say, look, we've got to prevent CRPS. When it comes to the nitty-gritty, when they want to pursue seriously injured status, they for some reason just refuse
Very
to go
resistant to going to IMEs on CRPS.
Yep.
Now, and I think it's that issue of the diagnosis and it being in place for 12 months, is that they don't want someone like Dr. Champion or back when Professor Cherry was practicing because the criteria at the moment is quite hard.
Yes.
But then once you get over that, if you get all the criteria ticked off, your assessment is quite high, there is resistance to going. Now, some of that might change because with the review of the impairment assessment guides, they are looking at changing the criteria.
That's right.
For the diagnosis, but then not having such enormous assessments. Like there'll be a greater variety in the actual assessment. So you won't, I mean, almost now if you are diagnosed with CRPS that qualifies, you're probably going to be seriously injured.
You would
but
think.
With this review, the aim is to make the diagnosis a bit easier, but the assessments will be potentially less.
Less.
So no
That's
guarantee.
right. That's right. And I think when you throw someone in like Dr. Champion, who's very well respected and very generally his opinion does hold a lot of weight in the tribunal against Dr. Siapdu's assessment, clearly that's Mr. Hussein's representatives' issues here. They're trying to protect Dr. Siapdu as being the only opinion before the tribunal. So, we rolled out the big guns and they're doing whatever they can to try and prevent that. So we'll update you once we know what happened on appeal.
Yeah.
On
In saying
appeal.
that it's good that they've got Dr. Siapto on the one hand, though, on the other side, rather than Dr. Dionys, because Dr. Siapto does make concessions during cross-examination, and that's something that I've discussed with our counsel in recent matters, which are not related to any of these issues. But Dr. Dionys, not so much. So who knows? To be seen.
So it is very much a watch this space, everyone. Hopefully, if the decision is out shortly, we can update you in our March newsletter. If not, we'll do it as soon as we sort of see it. Because as Tracy said, once the amendments push through to the IAGs, I suspect particularly where CRPS is involved, that might change a little bit. But if you sort of focus on these being what we have to take into account when we're making our applications to try and get a worker to attend the appointment or get the direction from the court, if we focus on those, I think what Judge Rossi is telling us is we've got more of a chance that we may have had in the past. On this side of the fence, of course. Yeah. Any other questions? No? I'll hand it back over to you.
Very quickly apologise to Paul Joying, because what I had planned on giving you, I forgot to bring it, so blame it on the baby brain. But it's okay, we've got a bit of a backup. Just want to give him another round of applause for coming out, volunteering his time. Thank you. I hope you really did enjoy the presentation as much as I did. Please stick around for some drinks. If you've got some questions, come and approach us. Thank you. Paul will also be sticking around, so if you want to pick his brain a little bit more, please do. We have recorded this session, so if any of your colleagues want to have a look at what was discussed today because they couldn't make it in this disgusting heat, then we will have the link hopefully in our next newsletter. If not, just keep a lookout on our website, and I'm assuming our practice manager sometimes also checks people on our mailing list.
I think she sends an email.
Yeah, with all the details. The only other thing I want to just say is if you have any other questions, particularly in relation to Section 18 or any of the other amendments that have been come into effect in December, maybe chuck us an email if they're general questions and not, us giving you for all advice. But if they are some general questions that you want to put to us, please do so. You've got the admin email address there, and then perhaps we can address it. If not in our next newsletter, then perhaps at the next seminar or another newsletter in the future. Thank you so much for coming out. Hopefully that was a useful and enjoyable presentation for you all. So now let's go and relax a little bit, have a drink or a few.